Welcome back to the Deep Dive, where we crack open the source material so you don't have to wade through every provision yourself. If you are currently staring down the barrel of civil procedure, specifically the foundational architecture of litigation, then you know we are about to hit some seriously crucial ground. This isn't just theory. This is about understanding the levers that control whether your case lives or dies on a preliminary objection.
Indeed. We are moving past the initial statement of claim and focusing intensely on the scaffolding of the lawsuit itself. We're talking about the rules governing the dimensions of suits, primarily found in Articles 33 through 56 of the Civil Procedure Code, along with, related provisions from the Civil Code. Our analysis today has to go beyond simple recitation. We need to focus on why these rules exist, how practitioners use them strategically, and, most importantly, what the Cassation Division has instructed about their interpretation.
Okay, let's unpack this. Our mission today is to master the shifting roles, the mandatory requirements, and the strategic devices that really shape the legal landscape of a case. We're looking at procedural optimization and, risk management in litigation. Before we jump in, a massive thank you and recognition to the respected lecturer and lawyer, Mr. Abdurahman Said. Your comprehensive lecture notes are the absolute bedrock of this exploration, guiding us through these incredibly detailed concepts.
Our deep dive into the formal structure of a suit will dissect what we can call the 7 pillars of civil suit dimensions. We'll begin with the parties themselves, then move to representation, joinder of both parties and claims, and then the dynamic entry mechanisms like intervention and third-party practice, or impleader. After that, we'll touch on the specialized action of interpleader, and finally the rules governing the inevitable change of parties due to events like death or insolvency.
All right, let's start at the very beginning. Article 33. Who gets a seat at the table? At the court of first instance, the core roles are, pretty straightforward. You have the plaintiff, who initiates the proceedings, makes the allegations, and then the defendant, who is the party the claim is filed against. These are the two essential poles of any litigation.
But those titles are volatile. As practitioners, you need to recognize that they are tied specifically to that trial court level. And here's where it gets really interesting for appellate work. Once a decision is appealed, the terminology shifts, and that reflects the new relationship with the decision being challenged. The party appealing the lower court's decision, the one seeking reversal, becomes the appellant.
And the one responding.
The party responding to the appeal, usually seeking to affirm the original decision, is the respondent. This small shift in terminology reflects a monumental shift in the procedural burden and the focus of the arguments.
Absolutely. And beyond those two core roles, we have a quick glossary of other potential players who can enter the suit later, often strategically or dynamically. First up, the intervener. This is a non-initial party who gets admitted into a pending case, sometimes midstream, to assert their own distinct rights or claims that might be affected by the outcome.
Then you have the impleader, which is formally called a third-party defendant. This is key for risk management. They are brought in by the original defendant, who claims this third party is ultimately liable for all or part of the original claim. This device is purely about shifting blame or securing indemnity.
And finally, the specialized device of interpleader. This is a form of joinder for a party, we call them the stakeholder, who holds property or funds but isn't sure which of several rival claimants they are truly liable to. The interpleader action forces those claimants to stop suing the stakeholder and instead, litigate against each other.
That's right. And you can find the detailed rules for this specific action in Articles 293 through 299 of the Civil Procedure Code, which we will definitely explore in more detail later.
Okay, so setting aside those specialized roles for a moment, Article 331 lays out the fundamental general requirements for all parties. Doesn't matter if they are plaintiffs, defendants, or interveners.
Requirement 1, capacity. Every single party must have legal capacity to sue or be sued.
And this takes us directly back to the Civil Code, right?
Straight back to the Civil Code.
Right.
Specifically Article 192, which covers the general rules of incapacity, things like being a minor, an interdicted person, or lacking legal personality.
And failure here has immediate disruptive procedural consequences. It's not a minor issue.
Not at all. If the court finds a party lacks capacity, Article 34 mandates that the court must suspend litigation.
Yeah.
The entire case just hits pause until proper representation is made, usually by a legal representative or a guardian.
So for a defense lawyer challenging the opposing party's capacity early on, that's a powerful move.
It's one of the most effective preliminary objections you can make.
That's right. Incapacity isn't just some side issue. It is explicitly listed as a ground for preliminary objection under Article 244-2. If you're defending a suit Challenging the capacity of the plaintiff forces them to reorganize and potentially incur significant delays, all before you even touch the merits of the claim.
The second general requirement is the vested interest requirement. All parties must have a direct stake in the outcome of the suit. This is really the constitutional and procedural cornerstone of standing to sue.
And when we look specifically at the plaintiff, Article 3D32 is what operationalizes this requirement. The plaintiff has to demonstrate a vested interest in the subject matter, and crucially, they must be the real party in interest for that specific claim. This defines their locus standi.
Which is just the right to bring the action in the first place.
A key strategic takeaway for law students here. Locus standi is determined solely by what the plaintiff alleges in their initial claim. You look at the statement of claim and ask, does the decree sought by the plaintiff benefit them or prevent a harm to them directly?
And if that vested interest is absent, what happens?
It becomes a critical preliminary objection under Article 244, allowing the defendant to potentially secure a dismissal of that named plaintiff. But the court has powerful remedial options under Article 33.
That's the subtlety. The court usually retains the power to order the substitution or addition of the correct plaintiff, the real party in interest. This can be based on the defendant's objection, or even sua sponte on the court's own initiative.
So the court prefers to fix the problem rather than just toss the case out.
Exactly. It demonstrates the court's preference for resolving the substantive dispute on its merits, provided the real party in interest can be identified and brought in. The objection serves as means of correction, not automatic dismissal.
That brings us to the defendant. Article 33.3 seems, well, far less stringent. It places almost no burden on them initially.
That's because the defendant is reacting to the claim. The sole requirement for a defendant is simply that there must be an allegation made against that person. If the plaintiff's claim includes an accusation of liability or wrongdoing against a named party, that party is properly brought in as a defendant.
Whether that allegation is true or not is a question for later.
Precisely. That's a question of merit, not a preliminary bar to being sued.
Okay, moving on from the core individual parties, let's discuss the circumstances when one person stands in for another representation. The source material makes a really interesting structural point here. Representative suit is generally the rule in most civil cases, and appearance in person is actually the exception.
That's a crucial insight into procedural economy. Appearance in person is typically limited to cases where the court deems it absolutely necessary for the proper determination of the suit. Things like confirming identity, facilitating a critical settlement negotiation, or, providing unique personal testimony. Otherwise, the legal system relies on representation through agents, legal guardians, or advocates to maintain efficiency and accessibility.
We can break representatives down into two broad types based on whose interests they are pursuing.
Type 1 is the statutory representative. These people act purely on behalf of others. Their own personal interest is not at stake. This category covers legal representatives for those under incapacity, which is Article 34, and agents, which you'll find in Articles 57 through 64.
For instance, legal representation under Article 34 is for persons under incapacity minors, those interdicted, and others legally disabled. The representative acts strictly as an organ of protection for that legally disabled party, making sure their rights are asserted or defended.
Type 2 is more of a strategic representation, where the representatives are advocating for their own interest as well as the interest of others. And this is the realm of collective action, which brings us directly to representative class suits under Article 38.
But first, let's quickly detail the other categories of Type 1 representation. We have representation by agents, that's Articles 57 to 62. This allows authorized persons, including family members under Article 58A, or other designated agents, to act on behalf of the litigant. And, of course, the most common form. Representation by pleader or advocate, which is Article 63 of the CPC and Article 2205 of the Civil Code. This requires the professional qualifications of an advocate's license and a formal letter of authorization from the client.
Now let's drill down on Article 38, representative class suits. This is defined as a suit filed by one or more persons on behalf of themselves and others having the same interest. This is the Ethiopian model of a class action.
The functional justification is pure procedural convenience, right? It avoids a chaotic multitude of individual suits, relieves the court's burden, and reduces the financial strain for large groups of individuals who have all suffered the same harm.
But, and this is a big bet, in the Ethiopian legal context, this is a very difficult mechanism to trigger. That's due to the strict requirements designed to protect due process. 4 crucial requirements must be met to proceed under Article 38.
Okay, requirement 1, same interest. Two or more persons have to share a common interest, a common grievance, and the relief demanded must be beneficial to all of them. The source material emphasizes that this commonality does not necessarily demand that the claim arise from a single cause or the exact same transaction.
Right, the shared interest in the outcome is the critical factor.
Requirement 2. The interest must be identical.
Yes. If they're plaintiffs, they must all seek the same relief against the defendant for the same wrong. If they're defendants, they must assert the exact same defense against the plaintiff. This identical nature ensures the court's ruling will apply equally and efficiently across the entire group.
And requirement 3, and this is the strategic differentiator that radically separates this system from many Western jurisdictions.
It's the big one. All persons so interested must agree to be represented. This personal, explicit agreement requirement is fundamental.
Okay, we need to pause and analyze the strategic implication here. Because the code mandates this personal agreement, it makes initiating the kind of sweeping mass tort or product liability litigation we see elsewhere.
It makes it virtually impossible here. In jurisdictions with opt-out class actions, where people are bound unless they actively refuse, you can gather a huge class quickly. This requirement ensures individual consent, but places a huge practical burden on the representative to go out and gather agreement from potentially hundreds or thousands of claimants.
Precisely. It trades systemic efficiency for individual due process protection. And finally, requirement 4.
Court permission. The suit cannot proceed as a representative suit without the explicit grant of permission from the court, which verifies that the previous 3 requirements have been met.
So once the court gives the green light, the binding effects of this class action under Article 38 are profound.
Oh, absolutely. The appointed representative gains control over the conduct of the suit. They manage the strategy, the evidence presentation, the negotiations, everything.
Which means other members of the class can't just object to the representative's strategy or appeal an order granted to them. Their only recourse, if they're dissatisfied, is to apply to the court to become a party to the suit themselves. But once they consent to representation, they pretty much yield control.
And this control extends to finality. Any compromise made by the representative binds the class members. Most importantly, all members are bound by the final decision, which serves as res judicata, legally preventing any subsequent individual suits on the same claim. That requirement for personal, upfront agreement from every class member truly reinforces the unassailable binding nature of the judgment against the class in this specific context.
Now that we've established who can represent whom, let's talk about joinder. This is the mechanism for bringing multiple parties or multiple claims into a single lawsuit. The rationale is clear. Procedural efficiency. We want to avoid conflicts and reduce costs.
Correct. Joinder devices aim to avoid multiple suits, relieve the court's burden, minimize litigation costs, and, crucially, prevent the possibility of conflicting judicial decisions regarding the same facts or property. A court finding liability for one defendant in suit A and non-liability for another defendant in suit B, based on identical facts, is the procedural nightmare joinder rules are designed to prevent.
We distinguish between permissive joinder, which is optional, and mandatory joinder, which is necessary. For permissive joinder of parties, that's Article 35 for plaintiffs and Article 36(1), and 2 for defendants, 2 core requirements must align for the court to allow it.
First, the claims must be asserted jointly, severally, or regarding the same transaction or occurrence or a series of transactions. This is the factual nexus. Second, a common legal or factual question must arise. If both of those conditions are met, joining the parties streamlines the process and is permitted.
Mandatory joinder, however, is a non-negotiable requirement where the court must require the presence of an absent party.
This is necessary when 1. The existing parties can't get complete relief without the absent party, or 2. The absent party's own interests might be impaired, or the existing party might be subject to multiple or inconsistent obligations if that third party isn't present.
This functional necessity leads us to the critical distinction between proper parties and indispensable parties.
And this is a distinction you absolutely must master. An indispensable party is a person without whom the suit cannot be effectively disposed of. Any order or decree made in their absence would necessarily affect their pre-existing rights or just be ineffective.
And the risk of missing an indispensable party is high.
Very high. Non-joinder of an indispensable party is often fatal. Even if the existing parties waive the objection, the court has to raise the objection sua sponte on its own initiative under Article 39(2).
Proper parties, on the other hand, are those whose presence is beneficial. It enables the court to adjudicate the matter more effectively.
But their non-joinder is an inconvenience, not a catastrophe. It is not fatal to the suit's continuation. The suit can proceed, though perhaps less comprehensively, without them.
We see specific examples of mandatory joinder for defendants in Article 36(3) and 4.
Right. Article 36(3) requires that in suits concerning property administered by multiple trustees, executors, or administrators, all of them must be parties to ensure the fiduciary estate is properly represented and bound by the decision.
And Article 36(4) addresses specific land disputes. If the plaintiff sues for the recovery of immovable property free of occupants, all occupants, whatever their claim title, even mere squatters, have to be made parties to the suit.
And that's to prevent the plaintiff from securing an eviction order that one occupant could later claim doesn't bind them because they weren't part of the case.
So, to identify indispensable parties generally, what should we look for?
Look for two groups. First, those who exercise their rights jointly. Think joint owners dividing common property or joint creditors. Second, those who will be necessarily affected by a decision rendered in their absence, particularly when the suit involves a specific res or property. If the decree will affect their rights to that property, they must be included.
Okay, moving to joinder of plaintiffs under Article 35, the requirements are strict.
They are. You need two or more persons with the right to relief, jointly, severally, or alternatively, where that right stems from the same transaction or series of transactions. This is usually interpreted as a unified event or a chain of events causing the harm.
And secondly, they must share a common question of law or fact. But here's the kicker you mentioned in the notes.
Yes, the plaintiff's claims must not be antagonistic to each other. You can't have two parties suing the same defendant in the same suit, where both are claiming mutually exclusive title to the same piece of land, even if the question of fact, like who currently possesses it, is common.
For joinder of defendants under Article 36, the rules seem a bit broader.
They are. Article 36(1) requires the existence of a common issue of law or fact. Notice that the same transaction or series of transactions requirement that applies to plaintiffs is not a mandatory requirement for defendants in this clause.
And Article 36(2) provides another independent basis for joining defendants.
Correct. Persons who are severally or jointly and severally liable on the same contract, think joint guarantors or parties to a negotiable instrument like a bill of exchange. In that specific contract scenario, a common question of law or fact is not required, only the common contractual document.
To illustrate how broad and strategically useful the common question of fact can be, let's look at that classic English case that influenced so many procedural codes. Bullock v. LGO Co.
Yes, from 1907. It's a great example.
Okay, so the facts are, a plaintiff B is injured while riding in an omnibus owned by Company L. The injury happened when Company L's bus collided with a cart belonging to Company C. B sues both L and C for damages, claiming joint negligence and, alternatively, separate negligence against each one.
The initial objection raised was misjoinder. The companies argued they couldn't be sued together. But the court held that the suit was not bad for misjoinder. And the reasoning is key. Why? Because the entire injury arose from the same transaction, the collision, and it involved a common question of fact.
Which is what?
Namely, how the collision happened and which company, L or RC, was truly responsible, or if both were.
The strategic takeaway for law students, then, is that it is not necessary that all defendants be interested in all the reliefs, or that the liability or the evidence regarding each of them should be the same.
Exactly. The common transaction and the common issue of fact are sufficient to permit joinder, which saves time and prevents two separate trials trying to figure out the cause of the same collision.
So what happens if parties are improperly joined or missed? Let's talk about non-joinder versus misjoinder and their effects, which are governed by Articles 39 and 40.
The crucial policy rule, stated right there in Article 39(1), is that the court is not supposed to dismiss the suit outright because of non-joinder or misjoinder.
So the priority is getting to the merits of the dispute.
Always. Instead, the court must deal with the matter regarding the rights and interests of the parties who are actually before it. This often means the court will order the claims to be severed, and separate trials will proceed against the properly joined parties.
And Article 42 gives the court the power to fix the situation.
It does. The court can strike out the name of any party improperly joined. Conversely, the court can also add the name of any person who ought to have been joined, or whose presence is necessary for the determination of all the questions involved.
While the plaintiff generally has the freedom to choose who they sue, Article 42, second paragraph, gives the court a bit of discretion to compel a plaintiff to join someone as a defendant.
Yes, specifically to protect the rights of the named plaintiff. It's a rare equitable power.
Okay, let's just reiterate the key procedural point from Article 392.
Objection to misjoinder or non-joinder is waived if not raised at the earliest possible opportunity. This is a strict rule of diligence. But, and this is the exception you must remember, this waiver rule does not apply to the non-joinder of an indispensable party.
Because their presence affects the court's very ability to render a binding, effective judgment.
Which is why the court must raise that objection on its own, sua sponte.
Finally, within this section, we have to address joinder of causes of action. That's Articles 217 to 221.
The general rule here is highly permissive. Parties are allowed to join as many causes of action as they have, even completely unrelated claims against the same defendant.
That seems like a major efficiency tool. If I'm suing you for breach of contract on Deal A and a totally separate tortious interference on Deal B, I can just combine them.
You can. But there are exceptions where joinder is not allowed. Specifically, claims for the recovery of immovable property under Article 218 can't usually be joined with other claims unless the secondary claim is purely monetary and relates to that land. Also, claims against a person in a representative capacity under Article 219 also impose certain restrictions.
And the court always has the final say under Article 221.
Always. If the joinder of causes brings delay or creates unnecessary embarrassment for the defendant, maybe forcing them to prepare defenses for totally distinct factual situations, the court may order separate trials or sever the claims.
So the complexity really peaks when you face multiple parties and multiple causes of action.
It does, because there is no specific overarching provision in the CPC for that matrix. As a practitioner, you have to simultaneously satisfy the rules for joinder of causes of action and the rules for joinder of parties.
And the court's guiding principle is always:
does this configuration enhance judicial efficiency and prevent inconsistent results across the board? That's the test.
All right, if joinder happens at the outset, intervention is about a party coming into a pending case midstream to present a claim or defense. It's a mechanism for dynamic entry, governed primarily by Article 41.
Exactly. Intervention is a question that arises after a suit has already commenced, maybe even after discovery has started. It is critical for parties whose interests only become apparent or endangered as the original suit progresses.
We have two types of intervention outlined in the sources.
That's right. Third-party application under Article 41 and the rarer public-focused public prosecutor intervention under Article 42.
Let's focus on Article 41, third-party intervention. The intervener can apply at any time before a decision is given.
They can, but the court will apply 3 very strict conditions before admitting them.
Okay, condition 1.
First, the intervener must show an interest related to the property or the transaction that is the subject matter of the action. This can't be a remote theoretical interest.
Second, they have to demonstrate a substantive right under the law which will be directly affected if the proceedings continue without them.
Put simply, they must be a person who will gain or lose by the direct operation of the judgment. If the judgment between the plaintiff and defendant will, for example, void a contract that they rely on, they meet this test.
And third, and this is a major hurdle for any aspiring intervener.
It is. The absentee's interest must not be adequately represented by the existing parties. If, for instance, the existing defendant has the exact same incentives and capacity to defend the claim as the intervener, the application will likely be denied.
So the intervener has to prove that the existing party is either being neglectful or colluding, or is just unable to fully articulate the intervener's specific defense.
Correct. The court wants to avoid the unnecessary multiplication of parties unless the intervener is truly indispensable or critically necessary.
If they're successful, the intervener becomes a full party, and the decision on the case also binds them. And we have some crucial guidance from the Cassation Division on the scope of their involvement.
Yes. Volume 20, case number 18647, provides a lot of clarity. The cassation ruling stated that an intervener is allowed to raise any defense, including preliminary objections, against the original parties. They are not merely passive observers, they are full litigants.
But there is a limit to their freedom, which I imagine is often tested in practice.
Oh, absolutely. The cassation ruling clarifies that the scope of the intervener's claim is strictly limited by the scope of the original claim between the plaintiff and defendant. If the intervener tries to seek independent relief, say, damages for defamation that are unrelated to the contract dispute being litigated, they won't be considered to be sufficiently interested in the existing suit.
So their intervention will be restricted or denied?
To that extent, yes. Their claim must be ancillary to or protective of the subject matter that is already before the court.
The second type is intervention by the public prosecutor, Article 42. This isn't about protecting a private interest, but protecting the integrity of the law itself.
Precisely. The PP intervenes in civil matters to protect the public interest and respect for the law. This usually happens in cases involving the status of persons, matrimonial matters, guardianship, succession, or the legal standing of organizations.
The source material references several key areas where the PP is explicitly empowered to intervene, which demonstrates the breadth of the state's interest.
It does. For instance, in the Revised Family Code, we find provisions concerning marriage, divorce, and parental rights.
Also in the Civil Code regarding the protection of legal personality, the interdiction process, guardianship, and succession matters, and in the Commercial Code, particularly in relation to commercial organizations and insolvency proceedings.
All of this just underscores that in civil justice, certain matters carry a profound public policy dimension that transcends the private dispute.
Okay, if the intervener comes in to protect their own interest, third-party practice, or impleader, under Article 43, is purely a strategic device. It's used by the defendant to shift or share liability. It's risk management in real time.
Impleader is highly strategic because it enables the original defendant to bring in an additional third party who may be liable for all or part of the original plaintiff's claim against them. The goal is judicial efficiency, resolving the entire chain of liability in one action, thereby avoiding the necessity of a separate follow-up suit for indemnification.
It's important to stress the optional nature here. The defendant is not forced to use this device.
Not at all. They always have the option to wait until after they pay the plaintiff and then sue the third party in a separate indemnification suit later.
But if they do choose to use it, the requirements under Article 43 are strict, especially regarding timing and substance.
First, the defendant must file the application with their statement of defense or during the first hearing of the suit. This is a strict deadline. Failure to do so at this early stage generally precludes them from doing it later. The court wants to resolve all preparatory matters early on.
And second, the application has to explicitly state the basis of liability.
Specifically, that the defendant is entitled to contribution or indemnity from that third party. The mechanism relies entirely on one of those two substantive relationships existing.
And third, the defendant must quantify the claim, mentioning the specific extent or amount of contribution or indemnity sought. They have to articulate a definite claim, not just assert that the third party might be liable for something. Okay, let's nail down the difference between contribution and indemnity, because this distinction is something that can trip up even experienced lawyers.
Right. Contribution, which you'll find in the Civil Code under Article 1897, applies where two or more persons have committed the same wrong or share the same contractual obligation. Think of joint debtors, joint owners who fail to maintain common property, or joint tortfeasors, where two parties' negligence together cause the same injury. The liability is shared proportionally.
And indemnity, on the other hand.
Indemnity applies where one party is entirely responsible for the whole claim, even though the original defendant had to pay. It's a mechanism for 100% reimbursement, or close to it.
Like an insurance contract.
Classic example, liability insurance contracts, where the insurer must indemnify the insured, or agency-principal relationships, where the agent is sued for a rightful act done on the principal's behalf.
Once the third party is successfully impleaded, they gain full procedural rights.
They do. If the third party fails to appear on the fixed date, that failure amounts to an admission against them, pursuant to Article 76. Once they're joined, they proceed like a standard defendant, and they can raise objections.
And they can raise two distinct types of defenses, right?
Yes. The third party can raise any objection regarding their own intervention, and they can raise any possible defense against the original plaintiff's claim. They essentially step into the original defendant's shoes to try and defeat the plaintiff entirely.
The Cassation Division has provided crucial guidance on the scope of defense for the third party in Volume 14, case number 79465. This case is essential for practitioners.
It is. The ruling clarifies the third party's two primary avenues of defense. Avenue A, argue alongside the original defendant that the defendant is not liable to the plaintiff in the first place, or argue about the excessive quantum of damages claimed.
And Avenue B,
argue that they themselves have no legal or contractual obligation to pay contribution or indemnity to the defendant. This attacks the very nexus linking them to the defendant's liability.
This leads to the most challenging aspect of that cassation case. If the third party argues from the outset that no legal or contractual relationship exists between them and the defendant, say, they claim the insurance policy elapsed, the court must sever that core dispute.
Exactly. The ruling states that the third party cannot be made a party in the current proceeding under Article 43 to litigate the preliminary question of whether the relationship creating the attachment even exists. That dispute has to be dealt with in a separate file. The purpose of Article 43 is resolving attached liabilities, where the indemnity relationship is presumed or readily apparent, not litigating the validity of the relationship itself.
But doesn't that ruling create a massive loophole, allowing a third party to just assert a denial of the relationship to force an inefficient separate suit, frustrating the entire purpose of Article 43?
That is the perpetual tension in procedure. The court is balancing efficiency with due process. If the third party denies the existence of the contractual basis for indemnity, forcing them to proceed in the main suit would turn the primary action, plaintiff versus defendant, into a trial focused entirely on the secondary contractual validity, defendant versus third party.
Which is extraneous to the original claim.
Totally. So the court severs to maintain focus. Article 43 assumes an existing viable attachment. If the attachment itself is the dispute, it needs its own file.
We briefly mentioned interpleader earlier, but let's dedicate the necessary time now, as this is a sophisticated and specialized device that provides critical protection for non-interested parties.
Interpleader, found in Articles 293 through 299 of the Civil Procedure Code, is a form of joinder open to a person, the stakeholder, who acknowledges potential liability for money or property, but just does not know to which of several competing claimants they are liable. The key is their neutrality and their vulnerability to double liability.
The goal is procedural safety for the stakeholder. They are essentially saying, look, I have this fund and two different people are suing me for it. I am willing to pay the right person, but I need the court to protect me from being sued again by the wrong person.
Let's use a classic hypothetical. Imagine a commercial bank that holds a large escrow deposit for a construction project. The construction company and the landowner both claim the fund is theirs due to an alleged breach of contract. If the bank pays one, the other will sue the bank immediately, exposing it to double liability.
So the bank, the stakeholder, can initiate an interpleader action. They bring all the rival claimants, the construction company and the landowner, into a single action.
Crucially, they pay the disputed fund into the court, or deposit the property with the court registrar. Once the bank proves it has no interest in the subject matter beyond ensuring its safety and is willing to abide by the court's order, it is usually dismissed from the suit. The court then compels the original claimants to litigate among themselves to establish the validity and priority of their respective claims.
So the procedure shifts from claimant A versus bank and claimant B versus bank to claimant A versus claimant B, and the bank just walks away protected.
Precisely. It permits the stakeholder to compel all claimants to a single action, where they fight over their res held by the stakeholder, eliminating the stakeholder's risk of multiple litigation or inconsistent judgments. For students moving into commercial or banking practice, the detailed provisions in Articles 293 to 299 are absolutely essential reading for executing this procedure correctly.
Finally, we must discuss the rules governing the unavoidable changes in the structure of a suit, primarily focusing on the death and insolvency of parties, found in Articles 48 to 56.
Article 48.1 gives us the core rule regarding death. The death of a plaintiff or defendant shall not cause the suit to abate if the right to sue survives.
Let's define abatement clearly, as it is a term with severe procedural consequences.
Abatement means the suspension or termination of a proceeding for want of proper parties. If a suit abates, it essentially dies, and the procedural bar against refiling immediately applies.
For the suit to continue after death, two strict conditions must be met.
First, the right to sue must survive the death of the litigant. Second, the surviving party, or heirs, must apply to be made a party to the suit within a strict time limit, 1 year from the date of death.
The question of survival is governed by substantive law, right?
Yes, specifically Civil Code Articles 826 and 1986. Generally, all rights and actions existing at the commencement of the suit survive to or against the heirs and legal representatives. The heirs simply step into the shoes of the deceased litigant.
Can you give us some definitive examples of survival?
Of course. Suits for possession of property, actions for specific performance of a contract that binds the estate or partition of property. These actions relate to material rights that pass to the successors. The nature of the claim remains relevant even after the individual dies.
But then we confront the famous exception, often cited in judicial decisions. Actio personalis moritur cum persona.
Yes, a personal right of action dies with the person. The right to sue does not survive where the relief claimed is so personal that it cannot be enjoyed after the plaintiff's death, or if granting it would be useless or nugatory.
And definitive examples of abatement.
Actions for damages for purely personal injuries, like defamation, assault, or emotional distress that did not result in death. Another clear example is an action for the reinstatement of a worker who was wrongfully dismissed. That right is personal to the deceased worker.
And the classic one.
The classic instance is a suit for divorce. If one party dies, the cause of action for divorce ceases to exist, and the suit must abate.
If a party fails to apply to continue the suit within that strict one-year period, the suit abates, and the defendant may be awarded costs.
But Article 53 gives a crucial safety net for the court system. There shall be no abatement if death occurs between the conclusion of the hearing and the pronouncing of the judgment. The court treats the matter as if the judgment had already been rendered at the close of the hearing.
If a suit formally abates, the effect is severe.
Very severe. No fresh suit can be brought on the same cause of action. The procedural bar acts as claim preclusion, reinforcing the finality of the court's procedural determination.
However, there is a chance for redemption, setting aside the abatement covered under Article 552 and 3.
Yes, heirs or legal representatives may apply to set aside the abatement, but they must do so within an even shorter window, 6 months from the date of the abatement. They must also prove they were prevented from continuing the suit by a sufficient cause, meaning a genuine inability to file within the one-year window.
The Cassation Division has provided critical guidance on how to interpret the limitation period for both continuance and setting aside abatement.
Yes, Volume 13, Case Number 62452, provides essential context for practitioners regarding the calculation of these limitation periods. The ruling clarifies that the 6-month period to set aside abatement, and by extension the 1-year period to continue the suit, must be interpreted in light of the Civil Code provisions regarding prescription, specifically Article 1846.
So what did it say?
The cassation ruling stated that the time lost for obtaining the certificate of heirs should not be included when calculating the limitation period. This is vital procedural clarity, recognizing that the heirs cannot act until their legal status is formally confirmed.
We should also note cassation cases number 1005626, that's Volume 18, and the one you just mentioned, 62452, from Volume 13.
Yes, they both emphasize the mandatory nature of the procedure and the time limits that must be strictly followed for continuing a case after the death of a litigant. Failure to adhere strictly to the time periods will almost certainly lead to irreversible abatement.
And lastly, for completeness, the rules governing the insolvency of parties.
Right. They are found in Articles 54 and 55. These provisions generally mirror the rules of death, substituting the insolvent party with a receiver or trustee in bankruptcy, provided the right to sue relates to the property that vests in the receiver.
We've covered a massive amount of technical and strategic ground today, from who stands where to when they can jump into or be forced out of the case. What this deep dive shows is that the architecture of a civil suit is a highly dynamic structure, not a static form.
Absolutely. For you, the law student and aspiring practitioner, mastering the distinction between an indispensable party and a merely proper party, or understanding the difference between contribution and indemnity in an impleader action, is what turns theoretical knowledge into strategic advocacy. These rules, Articles 33 through 56, are all geared toward ensuring judicial economy, completeness, and fairness.
The primary thread running through all these provisions is the court's relentless procedural drive toward resolving all related issues in one place. The court's ability to add or subtract parties, to sever claims, or to bind class members ensures that when a judgment is finally rendered, it is comprehensive, final, and minimizes the risk of collateral litigation. That procedural finality relies entirely on the precise execution of these dimension rules.
Which brings us back to the strategic challenge that opened our discussion on representation. Since the Ethiopian system requires the personal, explicit permission of every single class member for a representative suit under Article 38, does this requirement, while laudable for guaranteeing due process and individual consent, fundamentally limit the scope and effectiveness of true mass litigation compared to other legal systems? I mean, systems that allow opt-out class actions based solely on the commonality of issues.
You have to consider the practical implications for large-scale consumer or environmental litigation.
Does our system prioritize individual autonomy over the efficiency of mass dispute resolution? And is that always the correct balance? Something for you to consider as you move into practice.
That's it for this deep dive. We'll see you next time.